Good evening. I hope you are doing well. Myself, Rakhi Budhiraja, advocate and mediator, Supreme Court of India, host and POXO trainer, and I will be serving as a host for today's session. On behalf of Team Nivaaran, I warm welcome all of you in sixth lecture of 4th International Virtual Mediation Summer School 2023. Let's have a recap on the topics covered during last 5 sessions. Historical perspective of dispute resolution, development of legal system, culture, and conflict and styles of conflicts, conflict management, resolution, and transformation, introduction to mediation, definition and process of mediation, differences between mediation, conciliation, arbitration, and litigation, lacuna and disadvantages of this adversarial dispute resolution, communication skills needed for a mediator, verbal and non-verbal communication, negotiation, soft, hard, and principled negotiation, negotiation skills needed for a mediator as a facilitator of negotiation, conclusion and agreement in mediation. And today's topics are ethics and ethical issues in mediation, neutrality, and self-determination. And then the same will be elaborated by Ms. Uma Ramanathan ji. Ms. Uma Ramanathan ji is an advocate, mediator, and mediator trainer. Ramanathan ji, the bright star in the field of ADR, born on 15th April 1954. Uma ji is BA BL. Uma Ramanathan ji enrolled of March 1980, just 2 months earlier before my birth. And since then, practiced on the civil writ matrimonial jurisdictions in the High Court and other courts in Chennai, and in Debt Recovery Tribunal and Consumer Courts till March 2009. Umaji was trained as a mediator by Geeta Ravindraji, who is trainer in USA in the year 2006 and later on trainer also in 2007. She was certified by GEMS as a commercial mediator in September 2013. She has trained advocates as mediators in many parts of India in the programs organized by Mediation and Conciliation Project Committee, Supreme Court of India, orientation programs on mediation in the National Judicial Academy and in the Judicial Academy, Tamil Nadu for referral judges. Umaji has been the organizing secretary of the Tamil Nadu Mediation and Conciliation Center, High Court Madras since 2010. She is a member of panel of mediators and judges who drafted the Mediation Training Manual of India as an initiative of the Mediation and Conciliation Project Committee, Supreme Court of India. Umaji had presented papers in various aspects of mediation in national conferences and regional conferences on mediation, presented paper on restorative justice and mediation in the workshop conducted by Criminology Department, University of Madras. Articles by Uma Ramanathan ji, Conflict Assessment and Management, Systematic Mediation, What is the Mediator, reached the three components of self-determination, Foundation for Comprehensive Dispute Resolution, Confidentiality as Process Control Mechanism for Dispute Resolution, Advocacy in Mediation, Torchbearers in Mediation, and many more. So, after presentation by Uma ma'am, there will be 20-minute question answer round for the participants. Participants can raise their hands in the chat box. Now, I will invite respected Uma Ramanathan ji to enlighten us on the today's topic. Over to Uma ma'am.
Thank you, Rakhi, for this elaborate introduction. I must thank Nivaaran and SIMC and CLA for having given me this opportunity to share some of my views. It is always a pleasure to, share some of our thoughts and also to learn during the question and answers. And I believe that learning is done only when we share knowledge. And for that, I'm grateful to Nivaaran, SIMC, and the CLA for giving me this opportunity. Now, Ethics has become a topic of concern and of importance today, especially when we are thinking about legislation for mediation or how the practice of mediation has to be conducted. I think over the years we have done enough pitching of mediation as an appropriate dispute resolution, and people have bought the idea. So now it is up to us to establish standards of practice, to establish uh, norms by which the integrity of the process will be protected. And for that, we have to understand that ethics is important. Now, of course, we can't codify the entire for the entire field and say this is going to be the norm everywhere, because mediation is a very flexible process. But the major components have to be addressed, and that is what we will try to do today. At the outset, I would like to say that we have to remember there are certain basic rights that we have to keep in mind. When disputants come for resolution, the first thing they are looking for or they're trying to pitch is the right for truth. Most of them do not have enough information, or they do not have a proper understanding of the facts that they have. And so what they are looking at is information, or what the mediator is attempting to do there when the mediator is approached for resolution is to try to get them the correct information that it becomes knowledge and they are able to make an informed choice. So the first thing is everyone wants to know what is the real truth, or what is significant in making a choice. So the right to truth has to be addressed. The second is right to privacy. There are a lot of concerns and fears, and there are a lot of information that one is not able to share openly. And sometimes during mediation, we know that the other person, if they get that information, they may be able to make a better decision, or there is a reason for this person to withhold this information. So that right to privacy also has to be kept in mind. The third one mainly is right not to be injured. If we do more harm than is already there, then we are sabotaging the whole process. They are coming there because they are not able to resolve it on their own, and they are seeking the help of a third person. And as a mediator, or as a process, we should ensure that there is no further harm done, or at least the damage is controlled, even if they don't come to an agreement. And ultimately, it is a right um, to have done what is agreed. Because unless there is a commitment, unless there is an intention to act as per the agreement, the whole purpose of discussions or making a choice, evaluation, and arriving at an agreement would be a waste. So, once there is an agreement, there is a natural expectation for that agreement to be fulfilled or the terms to be complied with. So the right to what is agreed also has to be addressed. So keeping in mind all this, that is why we say there must be confidentiality, there shouldn't be conflict of interest, there must be competence, and there must be self-determination. So these are the four pillars on which the integrity of the process stands. I would say that we have to first, for convenience sake, I would say RED, read. We have to remember that it is the responsibility in the process and of the mediator to see that whatever is exchanged or whatever is discussed there and whatever is the agreement that is arrived at, there is a commitment and there is an intention to perform that. So if there is no such a volition to do something in a positive manner, then it is a responsibility of the mediator to terminate the process and not allow it, because already there is an imbalance of power. And if this responsibility is not recognized, we would be doing further damage. And the second one is ethics, as we've been discussing. There must be a certain sense of integrity. There must be a certain sense of accountability. And the third one, I would say, is a moral commitment or a duty uh, or an obligation uh, to participate in good faith. So I would say responsibility, ethics, and duty are very important for the integrity of the process. So, right from setting the stage, right from when the mediator starts the process, there must be a conscious uh, approach to address all these concerns. Above all this, I think that when parties come into mediation, it is because of a conflict. Otherwise, they are not going to come there. Now, when there is a conflict, there are three important factors that we have to keep in mind. One is the personalities, because it is the people who are involved there, the kind of personality they are, how they react. I will not go into what is a personality or the emotions and all that. But what we have to remember is that there is a personality involved, how they react, how they think. And so the mediator must be conscious of that. The second is the perspectives. It will be because of their social cultural conditioning. It may be because of their expectations, so many things. But personalities, perspectives, and the third factor is power. There is always a power which drives people to do something or to say something. So all these three factors must also be kept in mind. So what we have to understand here is that all interventions by mediators are based on perceptions and judgment on their own thinking, and it is never fully independent or disinterested in any absolute sense. So what we have to understand is that though we say neutrality, though we say integrity, we cannot really be that totally unbiased or neutral. But what we have to be conscious of and to do is to have self-control and to self-regulate. And that is the most important thing. So when we talk of a, one second. What's happening? I'm sorry. When we talk of neutrality, what we have to keep in mind is that there is a moral compass of the mediator. We should not let that moral compass affect how we engage with the parties or how we receive the information. So that is the first important thing in, to a certain extent, in keeping the neutrality. There is also a thinking today that in private mediation, because it is not just court and ex mediation, in private mediation, because people pay for the services, it is the obligation of the mediator to get them to an agreement. So then how do we balance this power? How do we do anything to ensure that there is some sort of, what shall I say, a trust in the process, or how do they accept this process? Now, also, we have to remember that mediation itself is a very complex and contextual and contingent. One second. I will have to stop for a second. I'm extremely sorry. So what we have to remember as a mediator when we are doing this is that mediation is not about just getting a settlement. It is just about settlement. There's a difference between not about just settlement and it is just about settlement. So when we say the latter, it means we are moving the parties from their positioning, from their prejudices. And so we have to remember that there are personalities, there are perspectives, and there is a power. And so we have to be conscious of how neutral we can be or how we can manage this. When we talk about ourselves as mediators, or when we talk about parties who come into mediation, we also have to keep in mind that when we handle these parties in a dispute, some of them are those who cannot think for themselves and look up to others. So they may need a third party in the decision making. Some of them will be emotional. And so their validation of their feelings or satisfaction of their feelings becomes important. Some see that, some feel that the immediate goals are important, the larger goals are not important. So we have to keep in mind all these factors. So when we do this, we have to understand that there is a difference in neutrality and impartiality, because we generally talk about neutrality and impartiality. When we say neutrality, it means we stand a little away, what we call as a balcony view. To the extent that trust is created, parties are able to confide, or parties are able to believe that they can share information. Whereas on the other hand is, when we talk about impartiality, it is finding out what are the needs of those parties and how can that be addressed. So in the first, neutrality becomes the means to an end, whereas in impartiality, it is the end itself. So we have to keep in mind that not only do we have to be neutral, although it looks the same, we also have to be impartial. We have to understand what is there. So what happens is competence becomes important. Do we have, of course, there is a debate whether domain knowledge is important, but do we have the competence to handle these people? Do we have the competence to understand what is their underlying needs? Are we upscaling our skills? Are we doing something to reach out and help them to understand what is their underlying issue? So it is not just about confidentiality and commitment. It is also about commitment to the process and to what is there before us. So in this process, what David Hoffman says especially is very interesting. He says there are paradoxes. First is that there is mediators' pressure versus party autonomy. Now, when we say self-determination, we'll go into self-determination later. When we say self-determination, generally it is understood as parties having control over decision-making. So there is a sense of empowering them, helping them to recognize what is the real issue, and for them to find out what is the, to evaluate and find out what will be the right choice they can make. But at the same time, especially in private mediation, when the goal also is somewhere to get a settlement or to help the parties to reach some sort of understanding about the whole thing, there is a sort of a mediator pressure which conflicts with, or could be a pressure on the party's autonomy. So we have to be aware of that, because sometimes we feel that parties are resistant or resisting concessions. They are not able to, they usually say, oh, okay, what is this the other person is going to offer? Or I have offered so much. I have come down so much. Now, what has he done? He hasn't done anything. So there is a lot of resistance to concessions, or being upset about whatever the other person has done is not enough. So we have to keep in mind there is a sort of because we say we have to nudge in facilitation especially. So how much of it is mediator's pressure and how much of space is there for party autonomy to make a decision? That is an important factor that we have to remember. The other one is, which I feel is very important, is mediator's presence versus party control. Now, what do I mean by mediator's presence? We see a lot of advertisements where they say, especially for banks, where they say, oh, we are here, you can trust us. So I think somewhere along the line, to make the participation effective, to engage with the parties, to make it as a credible process, the mediator must be able to instill as much trust as is necessary for the part, because after all, the mediator is a third party. So for the parties to engage and to be confident enough to share information, the mediator must have some sort of a presence, must have some sort of a influence, in the sense it is not coercion, but there is a sort of an assurance that I am here to protect and I'm here to help you to resolve. So that kind of mediator's presence is going to be juxtaposed with party control. Parties will be trying to take over control, especially when there's a power difference. Each one will try to say, okay, this is what can be done, or this is how it has to be done. The third factor Hoffman says is that mediator's knowledge versus parties' expertise. So there again, our domain knowledge, or how we, for example, if it was something about accounting, I remember doing a matter about, erection of a factory, all that. And then there was a dispute about revocation of bank guarantee because of some work not being done according to them. Ultimately, it was only accounting there. So we had to bring in an accountant to see how they had understood their accounting. So again, it is mediator's expertise or also mediator's knowledge. That is also there. At the same time, if the party has more expertise about the whole thing, say in a medical negligence or in some, where some expert opinion is needed. So sometimes, because of that knowledge also, they could be tilting the balance there. Now, how much of, when we engage with them, how much of candor can be there? How much of empathy is going to be there? The line between understanding their feelings, or if we have certain values which match with them, for us to cross that borderline will always be there. We unwittingly we do that. We in the name of empathy, we try to express that, yeah, I am able to understand, or what is it the other you're feeling here. So in that position, or giving them an example, when you talk about, when we are discussing evaluation or choosing something, there is a thin line where we could cross into candor or hold back as empathy. So how are we going to do that? That is why that self-control, which Daniel Goleman talks about, has to be there. Also, trust and transparency, he says. When we have knowledge, especially when information is being given, say for example, there is cruelty in matrimonial cases, or there is fraud, which a partner does admit that some accounts have been fudged. But he says, I'm not going to admit it in front of the other person. Or holding some money, and he says, I will not disclose it in front of the other person. But when we know that a choice is being made based on the information that is available, how far is a mediator going to withhold some information? Or because of this withholding, because we can't disclose without the permission of the other person, if the decision is going to be made, which we know maybe otherwise, and if the other person comes to know about it later, what will be their reaction to the process, or to the integrity of the process, or to the trust in the process? So again, there is something that we have to be conscious of about trust and transparency. Although we talk so much about validation of emotions, he says there is a process, there is in this process a space for venting of emotions, and at the same time, the mediator not being carried away by emotions. The mediator has to suppress their own emotions. Say for example, when there was a case where the father was sexually assaulting his 14-year-old son, and the boy graphically described to me whatever was happening. It was very difficult for me when I saw the father the next time, not to say anything, and I had to be conscious about every word I said, or how I looked, or how I held myself. So, when we look at these things, although it looks like certain concepts, it is a conscious preparation for the mediator to understand that these paradoxes are going to be there. More than anything else, we also have to understand that when we say confidentiality, there is also a noisy chatter going on within us, in our mind, that we know that these are things that are important and we are not able to share it with the other person. So how much of the communication can be shared, or how do we share that? Or even if we do it indirectly, is that okay? So those are the paradoxes he refers to. And he also refers to whether there is voluntariness or non-voluntariness because of the way we handle these things, and whether other people must be, like administration must be involved in mediation. For me today, especially in the Indian context, I cannot say about anything else, because people rush to the police. I feel there is a need for us to address how the government can also be cooperative in this, how the police can also be brought in, because a lot of civil cases also go directly to the police station. Recently, I heard about a matter where the police had forced the parties to enter into an agreement for payment of some money to the other side, although it was a civil dispute. So we have, all of us, I'm sure, have many such examples. So how is this to be handled is also something that we in India at least will have to think about. So looking at all these factors, what we have basically seen is that self-determination is a prime factor. Now, what is self-determination? We talk about empowerment of parties to have the courage to determine for themselves, to make the choice. We as mediators will be in control of the process, whereas they will be in control of the outcome. All that is fine to talk about, but how do they do this? How do we help in this self-determination? I think basically we have to understand that any opinion or any idea with which parties come in is based on their earlier interactions plus the social environment from which they come. So unless we understand their social cultural values, we will not be able to help them to move beyond the positioning that they find themselves in, to understand that they can listen, recognize, acknowledge certain facts and move from there. So what we have to understand is that first they must be given the space where they feel safe. And second, they must understand that it is for them to take responsibility for the decision making. The third is we have to also see whether they have the competence to do that, whether they depend on other third parties or elders, because in the Indian environment, at least, there'll be other people who will be the decision makers. And so if the decision making or if the conflict itself is due to the third parties, do we continue with the mediation or do we terminate the mediation? That is also very important. I'm talking about this especially today because after the amendment in our laws about the succession, in the Hindu Succession Act especially, a lot of women have been coming forward to file for partition. But in our culture, we know that the women are given something at the time of marriage or during various occasions. And so, or even some property in some places. And so when when the women come forward to file such claims, there is a resistance to that by the male members of the family, or there is an impossibility to deal with it also because they may not have the necessary resources. So is the litigation first driven by that party's need, or is it because of something else, or is it because of their understanding of what is their rights and expectations? That also has to be gone into when we talk about autonomy and competence. More importantly is what is the relatedness there. There must be some sort of a connection. Without that, self-determination is not possible at all. So I found something very interesting when I was looking up about this topic, and I found that Professor Lawrence Susskind says that there are two, and there is the practice of mediation itself is only to protect. It is only to monitor and control unfair outcomes. Whereas Professor Stillberg says it is supportive. So irrespective of fairness of outcome, if the parties have come to a decision, then we should honor. So I feel today there is a dilemma with the mediator. When we know that it is an unfair agreement that they have come to, and still parties are going ahead with it because of reasons of their own, do we support that, or do we allow them to go into that consciously, or do we do something else to help them to or get further information or whatever to help them find a fairer or stop them from making an unfair agreement? That I think is something which we will all have to explore, because most often we find that parties come to an agreement merely to end the dispute, or merely because they don't have the means to fight more, or because there are other people pressurizing them to do something. So we have to understand that in the process of engagement in as a mediator in the process, the first thing is initiation of relationship. How do we find that there is a connection? Because most often, especially between in a partnership, we will find the partners have gone so far away that they may not be able to sit in the same space or talk to each other. So it is first important to see what is a relationship and how can we get them to be connected. Some sort of a relationship initiation is the first step that we can take. Second is to assess how responsive are they to suggestions, to listening, to understanding what is the real situation there. Do they want to listen? Do they want to do something about it? Or they are shying away from any interaction? If they are willing to do, or if they can be nudged towards an interaction. How competent are they to interact or to share information? So in that way, I think the cardinal principles has to be that not only has a mediator to self-regulate himself or herself, but impress on the parties also that there must be some kind of self-restraint and self-regulation, must help them to move from saying you ought to do this or this is what has to happen to, all those should, to can this be done or would this be better? So if we change it from should to would, there will be a shift. And how we do that is the communication skills or the uh, management of the negotiation process that can help us to do that. So more, I feel important here is to help the parties to understand their responsibilities in the situation. I remember I was attending a program where there was a psychiatrist from New York who was talking about matrimonial disputes and how he helps in counseling them. And he said the first session that I have is often where I ask the parties to come both together and tell them how I will be conducting the sessions. And I would say, write down whatever has happened and try to tell me when we meet next. What is your responsibility for this situation? And I think that's a great idea for mediators also to adapt, because once they do a sort of a self-assessment, once they try to look inwards, what happens is they are able to be a little objective. There is a little detachment from the feelings, and they are also able to understand how this has happened, and they are able to address it. So once they come with this sort of a mindset, then what we can do is help them to understand that truth is not unitary. Truth has different dimensions, and they can offer contingent solutions which can be explored. Now, when I say contingent solutions, that will be the offers that they are making, and we make it clear to them that we can hold it confidentially, or we can discuss it with them and help them to understand why they are making it, or why it will be possible, why it will work for them. And I think the next step is also minimizing the power difference, or what shall I say, the negative effects of unequal power. Unless we do that, parties will not be able to, what shall I say, impose trust or to understand what is happening. The most important thing I feel is when we say responsibility, we have to understand that though parties come in, they may not be really coming in on their own, or they may not be willing to share everything. So validating their willingness is very, very important. Helping them to improve their relationship is important. Helping them to identify their role in the situation, and then helping them to understand what is their contribution to the situation and contribution to make it better. So in that way, self-determination becomes possible. When we talk about informed decision making, we usually say that once the facts are there, they are able to analyze and come to a decision. But I feel that these are the steps that are necessary for an informed decision making. When we talk about engagement, again, it is not only commitment and involvement, it is helping them to trust the process, helping them to reach out to the other. Though letting go is often said as a necessary part of the whole mediation process, I feel that letting go may not be the right thing to say. What we have to say is acknowledgement of what is possible there, looking at the possibilities and deciding which is good for them. So what we are doing, I would say, in this process is we are creating value. In the sense that people come with their own values, mediator has their own values. I'm not talking about those values, but parties come in claiming something. But we are creating a value or making them understand that this is what is possible and this and for them to explore and find out what will work for them. So creating value is by trust, by helping them to understand their responsibility, helping them to be committed to the process, making the process credible, making sure there's no conflict of interest. If we have been in any way connected with them, we recuse ourselves. If we feel that some of the values that they express are too hard for us to accept, or we will not be able to handle the decision making impartially, then it is better for us to recuse. So we have to understand that voluntariness and self-determination is hinged on all these factors. And so when we say creating value, we have to see that they move a step higher than from what they were when they came into mediation, whether they come to an agreement or not. The next thing is when they start sharing facts, when they start sharing information, when they start sharing offers, we help them to, when we are helping them to evaluate all that, we are also we should also help them to assign value. Why is it they are thinking like that? Why is it this information is important? Why is this should be confidential? So that assigning value is also very, very important. Only when value is assigned to all this, they will be able to exchange it with full faith. And once the exchange is done, this value goes to the other person. Exchange back and forth, evaluation happens, and then there is an optimization of value. Why do I say optimization of value? Because they choose that this will work and they agree to, they commit to do that particular act. And once that is done, there is an agreement. And even then, I feel that we have to help them to reassess, to see and to be sure that they are going by whatever are the terms that they have agreed to. Only then make them sign the agreement, give them sufficient time to do that. So I think basically ethics is not just about self-determination or neutrality or volition or conflict of interest or handling conflict of interest. It is about engaging with the parties, helping them to take responsibility for the decision making, helping them to trust the process, and on the whole, building up integrity of the process and making it a workable process. So briefly, to sum up, I would say that as we structure the process, because every time we do a mediation, we automatically see who are the parties, what is the issue, and then we have sort of a framework. And in that framework, we should ensure that these things are in place at any point, because we can't say this has to come first or this has to come second. At any point in this process, we have to ensure that these things are in place. We are aware of the paradoxes, and we also understand how to take this forward without in the way that it will not do more harm for the parties. When I say this, I also want to stress on the fact that today we feel that settlement is the goal in mediation, or at least the court demands in court next mediations. We have to be more conscious of the fact that we are not here just to get the disposals and to see that the court is not burdened. We are also here to see that parties leave with lesser burden than they came in, or they understand what they are doing. And even if they don't come to an agreement, we have changed their mindset. To that extent, the discussions that happen there have to be holistic. See, for example, when I was doing a particular mediation where in a matrimonial matter, where both the parties were abusing drugs and were alcoholic and had a child, or just a toddler, and apparently the woman could not handle it, though she was advised about terminating the pregnancy, she had gone ahead. And now when the child was crying, she couldn't handle it, she could not feed the child, and she was inflicting harm on the child, let's say. I knew she would not come, but when I explored with her on the one session that I had, I found that she had been sexually abused from the age of 14, and she had other issues with her parents and in her social environment, but knew at that point she would not trust anybody or not care to listen to anybody. So I had to terminate the mediation because she was not willing to come also. But then I left her with a word saying, I understand that you want to hold on to your child and you don't want him to have the child. And he had actually come out of all that drug abuse and all that. And he had a support system at home also. So I said, I know that you want to hold on to your child for whatever reasons. But then I just want you to think about what has happened to you and why you're angry with whoever has caused some harm to you. Would you like your child to go through life with this kind of feeling? Or would you want your child to think differently? And I heard later that she had willingly come and handed over the child to the father. So somewhere along the line, I always feel that though we don't get an agreement, and that has happened even in commercial matters, where people have not agreed at the table. For example, there was an insurance matter where a man had retired and there was a group insurance, medical insurance, where he had to, where the company had to pay for the insurance, and but unfortunately they did not because they believed that he was not a person to be trusted. And he had some kidney failure and needed dialysis on a daily basis, which was very expensive. So when he approached the court saying that these people should not, should pay for his treatment, they opposed, saying that for these reasons they had stopped paying the insurance premiums. But then one of the law officers did say that if he approached the CEO, maybe that something could be done, but not here at the table. And so we advised his wife to listen to him or to get his help and do something. So apparently she went and met the CEO who had personally dealt with this individual, who knew about him, but apparently there had been certain situations because of which this impression had been created. He understood and he gave her 3 lakhs, a check, which she came back and he was in intensive care at that time. And she wrote on a piece of paper, company has paid 3 lakhs, and showed it to him from outside. And she came and told us that he saw that, tears rolled down his eyes, and he passed away. And she felt happy. And she said, that is what I wanted. I wanted him to die an honorable man. So I think somewhere along the line, we need not be that concerned about not getting the settlement at the table. We will know it will happen somewhere, or what we have to see is changing the mindset. But in the process, if we are going to coerce parties or to tell them what to do, that would not also be advisable. But also we have to be conscious today that people are not only thinking of facilitative mediation. Of course, transformative mediation is also there. They are thinking about elder mediation, especially in community mediation. And there are a lot of other forms that are coming up also. So as we proceed in mediation, as we learn to do more mediation, or as this process itself gets honed up, we may need to define certain areas, shall I say, or concepts that have to be kept in mind instead of having definitions and norms to restrict the practice. And for that, we need to constantly debate and and exchange ideas so that we keep this process alive and and a process in which parties can willingly commit and be happy to be engaged in. So I will stop here. Thank you for giving me this time to exchange some of my views, and I would be happy to answer any questions that you have. I think Raki showed that she has some problem. I will try to check the questions and answer. Or if someone can help me in this.
Maybe those persons who are wanted to ask questions, they can pose the question in the chat box so that we can collect it from there.
That did, but I'm not able to get it on the chat box. The last question I saw was, should the fees be refunded if there is no agreement? I
Okay.
saw the question. I don't see who sent it. I'm not able to get it. Okay. In private mediation, yes, that's going to be a question that will come up. So we will need, especially when there are institutions handling private mediations, we have to frame rules for all of that. Today, as such, if you tell them it is only, if you tell them ahead that it is for participation in you're going to be there as a mediator to facilitate the discussion, and they will be in control of the outcome. Uh, unless you have agreed initially to refund the fee, I don't think you have to.
There is another question. How can we build trust in the process of mediation?
That's $1 million question. And I think that's where the mediator's presence comes in. To a certain extent, um, in our culture at least, when you have gray hair and you're slightly largely built, people tend to trust you. Of course, that's on the humorous side. But then I think the way you converse with them, the way you engage with them, that matters. See, why does a party come to an advocate? I mean, any disputant comes to an advocate in the first instance. They may have seen your work or they may have heard about your reputation. The same with a mediator. So they may have heard that you would be able to help them, and then how you engage with them and how you build the confidence depends on how you converse and how you exchange information or how you help them to see the other dimensions to the dispute. So on the whole, it is just your skills and techniques that is going to help you to build trust.
There is a question from Vijay Kumar. Madam, how to get ourselves equipped or evolved ourselves with out of box solution?
I would say first that we are not here to give them out of the box solutions. It is for the parties to find out. But then this lateral thinking will not come automatically. So we have to nudge parties indirectly to help them to think beyond what they are thinking. That is where the positioning happens. They are not able to think beyond that. But this out of the box thinking will happen only when the mediator is able to get clarification for them by this repeated summarizing and validating the emotions, getting more information, and then telling them, maybe in another case, we had, see, that is where I find this co-mediation helps. You can turn around to the co-mediator and say, remember in that case, this happened. It may not have happened, but if you sort of put it in this indirect way, they get the information. Or you could say, look, if you're having difficulty, I remember in a case this happened. Would you like to explore that?
आवाज मत करो.
Those are the kind of things that you can adopt. Yeah.
Okay. Another question is from Varsha Shetty.
Yeah.
Hello, madam. If the mediation is not successful, the issue is referred back to the court. Is there a chance for another mediation session?
Sure. They can be sent for mediation any number of times. If the parties are willing or if the presiding officer feels it has to go back. See, we always say there is a certain sense of litigation fatigue that has to set in. Sometimes when parties approach the court itself, they are ready. Sometimes it takes some time. There is an opinion that when they come to the high court or further up in the appellate stages, one party has won, they may not agree. But sometimes waiting in court makes the other party also agree for a discussion. It depends on how you make them connect, or the understanding of the relationship, or if there is a future in the relationship, and also whatever the resources that are there. If there is very limited resource and one person is one, they are definitely not going to give it up. For example, there was a partition case where I was doing, where the father had given one portion of the property to the son, another portion to two of the daughters, because one daughter had, of course, you know how it happens in India. She had fallen in love with somebody, married, so the family disowned her. So at one point, she had come back to the father and asked, and he had given her about 20 years back, he had given her 2 lakhs. So he felt he was doing a fair deal when he did this. But now property prices have gone up and the situation has changed in the law. So she came back and she said, what was given at that time was a very low amount. Today, the property value is something, and so I have to be given. And this happens often. And the lawyers also support them, saying, after all, she's the daughter of the house. And what did she get? She must get something more. So there, balancing that and helping them to understand, they will go back and they will come back again, I'm sure.
The next question is from Dr. Kishore Dere. How do you strike a balance between neutrality and impartiality?
Yeah, that's the biggest question, because first, I must understand that my own biases, I must be in control of myself. I must be able to regulate my thoughts. Impartiality is where I know that this person has a resource he's not willing to give, or he understands that it is his responsibility to share, he's not sharing. And there must be some kind of, there's information there which I am privy to, but I am, because of this process, I'm not able to share with the other person. So neutrality is where I try to empower both of them in a similar manner, or am able to treat both of them equally. Whereas in impartiality, what happens is I have some information, and that should not impact how I communicate with the other person or how I receive the information from the other person. So that, the conscious self-regulation and all that, once we start practicing, we'll be able to understand how this happens. See, for example, in India especially, this word dharma is a very common word that is used. And all of us, say this is, it is used in the context of law, it is used in the context of equity, it is used on what, in the context of what is fair. So naturally, there is when a person uses the word dharma, they are expecting the other person to be fair. Now, what is fair comes with an inverted commas. It depends on their conditioning, on their values, on how they look at it. Yeah. It's just like that. It's all very relative.
Thank you, madam. Rakhi Budiraja, our host,
Yeah.
she has made a statement. The biggest learning for me, it is not about commitment to parties only, it is commitment to the process also.
Yeah, exactly. Thank you.
And then there is another question uh, from Bindu Shri, pertaining to instances where there is settlement outside mediation. After its conclusion, would the mediator's report reflect as settlement, or would it be considered as a failed attempt at mediation?
Uh, if the settlement has happened after it has gone back to court, unfortunately, we don't get credit. As I said, we change the mindset, the thought process, the pattern of thinking changes. And sometimes, especially in India, people are waiting for somebody to affirm that it is the correct decision that we are taking. We like a big seal on whatever has to happen or whatever we agree to. So once it goes back to court on the same terms or a little variation in that, parties may agree. And I've often said, please inform the center so that we know in the statistics how many of those cases got settled once it went back to court, but unfortunately, it is not being done. But once if the settlement doesn't happen when we are doing the mediation and we have to refer it back to court, we will only say not settled. Or sometimes we will say even unfit for mediation at this point. So once it goes back, even before it reaches the court or before it is taken up in the court, if there is a settlement, that also happens. Sometimes the advocates come back and say, now we have come to an arrangement because so-and-so said, or the parties rethought about it. In that case, we can always record it and send it back to court. So it always depends on the situation. Sometimes the court also, when listening to the parties at that point, send it back to mediation if some finer details have to be reworked. For example, there was a matter in the family court very much earlier on, where it was, today because of all this, social media and all that, where people take photographs and put it up on the net, and This was a case where the man was taking nude photographs of his wife and putting it up, and he had a girl child and she didn't want to stay there. And it was very difficult to get them to an agreement. And finally, they did come to an agreement where he would visit the child, and they were Catholics also. So he would visit the child in church on a particular Saturday and all that. So they had finished this agreement on Thursday, and the agreement went back. But on Friday, she had an offer in her office to go to US. So it was not possible for her to bring the child every Saturday to church, or they agreed Saturdays to church. So she asked for change in the terms. The man who took nearly 3 months to come to some sort of an understanding till then, within the 3 days, when the matter was again posted back on Tuesday or something, he agreed that when he went to US, he should be allowed to visit the child. And when she came to India, or the child to be sent on specific dates for vacation. So that is why I'm saying once the mindset is changed, there will be adjustment of other possibilities and options. So that can also happen.
Thank you, madam. There is another question by Nasreen Fatima. Hello, madam. What will be the status of a settlement agreement which is done out of the court settlement, and what is the law validity towards those settlement agreement?
If we're talking about a private mediation today, until the act comes, we don't know how this is going to be dealt with. But we in FCDR do it as award on agreed terms. We ask them to give a letter asking for conciliation, and then their conciliation stroke mediation. And once we do the mediation after the other party comes, what we do is get the agreement drafted and signed, and then the mediator, whoever has done the mediation, passes it as an award on agreed terms under the Arbitration and Conciliation Act. So that is what we can do at present. In court, of course, the parties sometimes choose to file a compromise memo under Order 23, Rule 3, or sometimes they even say, we have come to an agreement, so we can go to mediation and record it. Now, most of the courts have 138 Negotiable Instruments Act, which is check bouncing. And today, there is a problem about recording agreements arising out of anticipatory bail applications and criminal complaints. Some courts take it to Lok Adalat and record it. So again, there is a lot of confusion about how to do it, but yes, people are working out how to handle compoundable offenses, how to handle these negotiable instrument act complaints and all that. But I think we will get clarity once the act comes in about how to handle this.
Thank you, madam. There is another question by Wasiuddin Dadni. Madam, how to handle difficult and violent party terminating the mediation is the only solution?
I read something about saying we are angry because we don't know how to handle what what is there. So most of the parties, when they are violent or they are disruptive, let's say, they are not. We feel that they are not reasonable. There is a book called, by Sheena, I forget the name, Sheila, handling difficult conversations. Most of the people, they are being difficult because they have a false sense of expectation, or they have, especially in India, I find that settlements are made and then cancellation of settlements are made. And even the advocates tell them, after all, it was his property, he has a right to cancel it. There are only certain instances where it can be cancelled, otherwise it cannot. But unfortunately, they get such advice from their lawyers also, and so they are adamant. So yes, they can be difficult sometimes. Now, how we start the process? It is not just about spending 15 minutes in the introduction. It is not just about listening to the parties and summarizing it. It is about how we engage with the parties, how we build trust. And in the event of the parties being difficult, you can always, of course, adjourn, or you can have a caucus, you can have individual sessions with them. Find out what is the concern or fear because of which they are reacting like this. See, there was one David Marlon, who is a psychotherapist, who was born in India actually, to a Britisher, and he's moved back to UK. who says in conflict, what we have to understand is that there is anxiety, there is feelings, and there is defensiveness. These are the three factors which contribute to a conflict. So people will have anxiety about getting or protecting their space or getting what they want. They will have feelings because of whatever has happened or what they perceive about the situation. And most often it is to protect themselves from being hurt or losing. Let's say there is a risk aversion often. Because of that, there is an attitude. So attitude is mostly because of personalities. As I said, it is important to understand personalities, perspectives, and the power. It is also important to understand the anxieties or their concerns, their feelings, and their defensiveness. Once we go through this sifting of information and reassessing of information based on these things, we will help them to move away from being difficult to being very cooperative. For example, when this partitions matter, I said, where this daughter was given just 2 lakhs, the elder sister, who has helped her father financially and physically also, would not even sit near her sister. And she was making all sorts of allegations against the other sister's husband. But once we started engaging, and once I tried to get the facts from them and made sure that each person was not shouting and each person had time to talk about it, so she came out and she, or the person who was resisting the mediation and said she was not willing to discuss at all, said that she had some documents or she had some information which she would like to bring in the next session and talk to me. So I think that is where engagement comes in. And someone asked about anxiety feelings. The third is defensiveness.
Thank you, madam. Uh, Next one is by Sanjeev Kumar. What technique as a mediator need to use if parties to the matter is not a state of mind to reach on some amicable solution?
Sorry, can you repeat the question, sir?
What technique as a mediator what you needs to use if parties to the matter is not in a state of mind to reach on some amicable solution?
Most often when they come, they don't want an amicable solution, especially in court mandated mediators. They say, oh, he asked for mediation. I didn't ask for mediation. So why should I even offer something or even exchange information? So again, as I said, it is how we engage with them. See, it's like this. Especially in India, you will find that people go to the nearest pharmacy saying, I have a headache or a stomach ache and get some tablets and they swallow. Only when it becomes persistent, they go to a doctor. And when the doctor says, do these tests, they say, oh, this man is always like this. Make us pay for all this. These things are unnecessary, actually. So the same thing happens when they come to litigation or come into mediation also. They feel that they've already paid their lawyer, they have paid their the court fees, and they have been waiting in court for a long time. And why should they engage here in mediation or try to sit in the same space as the other person with whom they have an issue? So as long as when we talk with them, as long as we remove the words conflict or problem or anything negative, start giving them hope that something can be done. That is why I said finding out what is a relationship, whether there is a future in the relationship. If there's no future in the relationship, they are not going to think about a consensual agreement at all. What is the need? So they're not going. So there must be something in which they can invest. We have to find out what is the value that they're going to get out of this. That is why I said just not creating value, assigning value to that, helping them to exchange the value. Only then they can be optimizing of value. So the process itself is that. But what we have to understand is that though we know the concepts, the parties do not know those concepts. So we have to help them understand.
Thank, thank you very much, madam. Another question is by Tarun Kant Samantray. Admitted false complaint of 376. Whether it can be mediated as emanated out of matrimonial issues.
Unfortunately, today in anticipatory bail applications, all these are sent. And sometimes, though it has been a consensual relationship, they do take this view uh, when the relationship doesn't go further, let's say. Also, custody matters matters are also taken up in HCPs against which I have these matters I feel need a psychologist also there, because there are certain feelings which they really don't express fully, or the mediator is not equipped to handle at that point of time. Even these sexual harassment cases, I find sometimes whether it is the child or whether it is with an adult, sometimes we need the help of a psychologist. And in some cases, I've been able to ask the judges permission to take the psychologist. Yes, it is difficult to handle those cases, but sometimes, it is also initiated by somebody for various other reasons. For example, even POXO today is being misused like that. Um, I I remember somebody came saying that he had gone with a creditor to recover money from a debtor, and because the debtor couldn't pay, on the advice of somebody, the debtor had given a complaint under POXO for saying that these people had abused his 6-year-old daughter. Similarly, 376 has also been misused, where these women come and, or because sometimes property issues are involved, and they use this. And I always feel that in India, especially because of the backlog and because of the delay, people think that police can resolve their issues, and once they go to the police, mostly it is the police also who draft such complaints or give them ideas about such complaints, especially dowry harassment and domestic violence. So I won't say that totally they have to be ruled out, but we have to handle them very carefully, or send them back if there is something of an issue where evidence is necessary, or it will cause more harm, to be sent back.
Thank you, madam. I think Raki has come back. I request her to continue with the questions. Could you chip in, Raki? Raki Budiraja. At least I'll read out her question now.
Okay.
Her question is, in family cases, mediation generally, the minor kids are used to accompany. What is your view about it? Will it not affect the mental health of the kids? Kids should be allowed in mediation or not?
Uh, even in court, I don't think they should be allowed, so much less mediation, because obviously they'll be tutored, or they come with some pressure. See, it's like this. I feel when we go to a new country or a new place and we check into a hotel room and we go to sleep, if we wake up in the middle of the night, we are a little disoriented. We try to remember where we are and which side is the door, or which side you have to turn to switch on the light and all that. It takes a few minutes. Imagine the plight of a child who is taken away from familiar surroundings and put somewhere, or is being told all sorts of negative things because of which a child is apprehending safety and security. So I don't think the child should be called, but sometimes the children are brought into the mediation center because the parent doesn't have anywhere to leave the child, or sometimes the court also orders the child should be heard. I have made arrangements in our center for the child to have some crayons and paper and to draw, and I leave it with the person who can take care of them. Get some chocolates or something to keep them engaged while I talk with them. And in one particular case, I found it very helpful because it was between the maternal grandmother and the father. Apparently, the mother had died of some thrombosis, and it was an interfaith marriage where the mother was a Catholic and the father was a Hindu. And he had agreed to convert to Christianity to marry her. But ultimately, he could not remain a Christian. And so that was a sore point between them, even during the mother's lifetime. And the grandmother, who was a staunch Catholic, was a nurse. She herself had been busy with her profession, and she was guilty about leaving her daughters in the care of somebody else. And so she was holding on to the granddaughter, believing that she could take care of the granddaughter and also bring her up in the Christian faith. So when the mother passed away and the grandmother snatched the child from school and left to an interior part of Tamil Nadu. He was able to trace her and find out. And then when this matter came up, we were discussing. And when I gave the paper and crayons to this child who was sitting outside, drew a house, some trees, and because I'm sure she was living in the village where she saw all that, and she drew something like that. And then she drew a man on one side of the house and a woman on the other side of the house. So when I finished that session and I called her in to say goodbye, I asked her what she drew and she showed me that. And so I asked her, what is this? So then she said, this is my father and this is my grandmother, and I want both of them. And I showed it to them and I said, this is what your child is saying. She wants both of you. Do you want to exclude one another in her life now? She doesn't have a mother. He agreed to leave the child with the grandmother and asked just for visitation rights. So I think sometimes those expressions that the child makes from the subconscious mind helps. But I would definitely not like to bring the child in and question or talk to the child. Because even I have attempted, because of court orders, to visit the child in ice cream parlor or somewhere else where it will be child conducive and talk to them. But I know that meeting me for the first time somewhere outside doesn't make them comfortable enough to talk to me. And it's worse in Zoom mediations. When you do it online, especially when there is harassment involved or alleged, I find it very difficult to connect with the child for the child to really express uh, his or her feelings. So I think we have to take it as each case and find out what can be done. But generally, asking the children, I don't think is that advisable unless you have a psychologist who can help you in this case, or the court can also send them to a psychologist for this.
Thank you, madam. Another question is from Mr. Jones, Adinher Jones. What general guidance would you give the mediator regarding the child's self-determination, where a child is torn between the parents in difficult mediation, taking into consideration child's rights and parental right to parenting time?
So it's very unfortunate that the child is being used by the parents for their own. I remember there was a HCP and a matrimonial dispute in which the matter was referred for mediation, and the father was living in USA. The mother had come back with one child. Two other children were living with the father. Now, this young child, although this lady was a lawyer, young child was with her and he was allowed visitation when he came to Chennai. So he would come here for a weekend, take the child to his hotel room and stay for the whole day and bring her back. And on one particular occasion, apparently, he changed the dress because the child had fallen into the bathtub and she had become wet. Now, she used that to say that he had touched her inappropriately. I feel the lawyers should also be very wary about making such allegations. Of course, the matter couldn't be settled at that point because it went back to court, and then later on, I heard that it got settled. But these things happen, and I feel a lot of parental alienation is also done, and there's also a lot of parental pressure. And unless we get some guidelines, uniform guidelines in child custody matters, it's going to be very difficult for the courts also. Because today I feel, even with the High Court, I'm sorry, unfortunately, we are not sensitized to see the needs of the child. First happen, the courts look at whether the parents are educated, they are working, and they say they are educated. So, what is the problem in their having the child? But we know that there are a lot of personality disorders or borderline disorders because of which the parents can also act in particular ways where it will be harmful for the child. Uh, Sometimes the children become adults by the time the whole process ends, and it is very unfortunate because of which the child's personality also changes. But I only wish that there can be a process where a psychologist can assess and the court can also look at that and help it. Because in the Domestic Violence Act, there is a provision. But unfortunately, in the marriage laws or in the Guardianship Act, there is no such provision.
Thank you, madam. I'll ask a last question for the day. This question is from Jyoti. Why mediation in Indian courts especially the district court, does not work. What changes you see in the near future?
Does not work in the sense in mediation centers.
That seems to be her understanding. She says, why mediation in Indian courts, especially the district court, does not work.
See, unfortunately, the government, I think it was in the 13th Planning Commission, granted 1 crore for each district to have a ADR building. But money was not given for other infrastructure or other things. So the buildings came up, and even those buildings are not, according to me, ideal for conducting mediation, because just certain rooms were built and given. Now we need rooms where we can sit and talk to the parties, and we need rooms for private or separate sessions. All that is not provided. That is one thing. Training was also done at the district level, and unfortunately from the taluk level, courts send the matters to the district level, and the mediators are there only in the district level, and even then only 4 or 5 mediators. So there is a delay in the handling, or the parties don't come. Lawyers don't want to engage in mediation because they feel it will be a dent in their income. So even mediators in the district level who are lawyers there do not encourage their parties when mediation comes from the taluk level to the district level. They say you need not go. So there are various factors. And today, of course, some money is given to the centers. But unfortunately, even drinking water or basic facilities are not there. Parties are not able to come there. The other factor is that uh, because we have been doing an assessment in Tamil Nadu of the district centers, I know that even the judges send to media, especially only family courts send matters, and they send it just 2 or 3 days saying, okay, it's only a maintenance matter, madam. It's only the quantum that has to be decided. So why do they want more time? They don't understand that the parties have to rethink whatever has happened between them to analyze the situation and then come to a decision. So even if just an 125 maintenance is being referred, parties have to understand whether their positions will work or whether they have to take a different stand there. So even when some of those people say, okay, she lived with me only for 3 days or 3 months, why should I pay? So then we will have to go back into why they think like that, and what was the situation because of which they are separated. So we need more time on all that. And that is because the judges are not sufficiently trained or sensitized about what mediation is. And they are looking at mediation only as a process to eternally send the cases away from their court or to lessen the burden of the court. They don't understand that even partial mediations can happen, partial agreements can happen, sorry, and those can be recorded. As of now, I think only Kerala has, because it's a very small state, and their high court judges have also been very seriously involved. They have gone to every district every month and sort of mentored and monitored them. And so at the district level, they are doing a very good job. Now, legal aid gets a large amount of money from the government. So there is another factor here also. The government must be able to spend more money on this. Unless they give enough money for infrastructure, or some of I know of a judge in Coimbatore who got the prison inmates to refurbish old furniture and he put it in the mediation center because he didn't have money to buy furniture. So these are all proactive things that have to be done. Today, there's one court where the district judge refers, orders cost to be paid to the mediation center. And in that particular district, the secretary tells me that she has enough money for infrastructure. If space is provided by the government, she would be able to provide everything else there for mediation. So all this is an ongoing process. Now, how we work with the administration, how our courts also understand, because they are also handicapped by not having enough judicial officers. Each judicial officer is taking charge of some other court also, so they don't have enough time to deal with the Section 89 CPC hearings. Don't happen at all because they don't have time, or they feel that lawyers send petitions about them to the High Court. So it's very, it's, I think on the whole, it is not just awareness, it is sensitization of all stakeholders, making it, changing the mindset to the level that people don't think of going to the police first, but think that they can do something on their own to resolve their disputes. So I think somewhere along the line, the self-determination is not just a concept, it is something that has to evolve from inwards. So even for us mediators, when I talk about mediators' presence, it is looking inwards, looking at how we can be more available to them, be more understanding of the situation. That is also important.
Thank you very much, Madam Ramanathan. Whenever we think in terms of ethics, and then we try to connect ethics with mediation, it is a very difficult situation to understand and imagine all this. But the way your exposition today made look these things very easy. It was very easy to understand. Your exposition made this look this ethics part connecting to mediation so simple. Thank you very much for that exposition. And then it is not for the first time we in Nivaaran are saying you have taught a batch of students in the year 2019. So all of us remember uh, how good you were as a trainer. And then you used to very, what you call it, in a witty way, conduct classes so that people are not only attentive, but also digest what you say. Thank you very much for that exposition. Thanks for your time. And then thanks for accepting our invitation and to be with us today. Thank you
Thank you.
so much. But
Thank
before I wind up, let me also remind all the participants that tomorrow's session is on online mediation. Justice Sudhir Jain, Judge of the Delhi High Court, would be with us, giving his exposition on online mediation. A very great and experienced person in the field of mediation. And our host is going to be Vinita Sahai, and we will come back tomorrow. And I request you all to come back tomorrow and be with us at 5 o'clock Indian time, 12:30 UK time. Thank you so much.
Thank you, Mr. Santanam, for this opportunity, and thank you all for being here and asking those questions so that I was also able to think about all those things. Thank you.
Thank you so much. Thank you. Thank you.